Ladies and gentlemen, you're looking at a Politico article behind me. The last live stream I had, you had a Vox article, I believe, behind me. And no, an Axios article behind me in my last live stream. Hit subscribe to this channel. You will hear the justices tell the world that Trump's going to get partial immunity. Hit subscribe to this channel right now. He will get an enormous victory with partial immunity. I have been saying this for a long time. A speech is not a criminal act, and that's just one of the reasons Trump will get partial immunity from the Supreme Court. The indictment was so broad and vague and ambiguous. Presidents are protected for official acts. The problem is that the special counsel did not differentiate what was official and unofficial. And so Justice Alito stated, hey, why don't we just give this to lower courts to find out what's official and unofficial? You'll hear that in a second. Hit subscribe to this channel right now. This is a huge, monumental, landmark victory for the rule of law and for Donald J. Trump and for this country. I want you to listen to this. I won't interrupt, but this is exactly what I have been saying, ladies and gentlemen. Then we'll talk about why this was such an enormous victory for Trump. And thank God this took place today. I have been telling you this for a long time, people. Hit subscribe to this channel. Listen to this brilliant exchange where justices completely eviscerate the absurd special counsel argument, trying to imprison Trump and setting a precedent that would really hurt this country going forward. Hit subscribe, listen to this right now, and we'll get to the analysis in a second.
Defense would prevent it from being considered a violation of law to go after a terrorist, for example.
Well, the Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said, but there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So I don't want to overstate Your Honor's concern with potentially relying solely on good faith. But that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct. They labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution. This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding. The framers did not want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because, Justice Alito, of the general principle that courts construe statutes to avoid serious constitutional questions, and that has been the longstanding practice of the Office of Legal Counsel in the Department of Justice.
All right, so this is more, I think, than just a quarrel about terminology, whether what the former president gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine, I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time, and during the trial, the former president may be unable to engage in other activities that the former president would want to engage in, and then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term. Congress is unlikely to crank up the machinery to do it, and if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all. So
you're arguing against most far-reaching aspects of Mr. Sauer's argument, right?
That is correct, and let me turn then to why.
Well, what about to unpack it a little more? Do you agree that there are some aspects of Article II presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument this question that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute, and I don't think that that's necessary in order to afford adequate protection for the president's valid Article II functions.
When you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United States can be used against a lot of.
If you're ignoring AI,
activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically is the risk that and going forward the risk. So you can take all of that.
I think that the question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president. Justice Gorsuch, Section 201 does not specifically name the president.
I would assume that's personal. So,
I think that
that's what Brewster said.
bribery statute in 607 says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
Is that a form? I mean, we can call it immunity or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize. And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through. And it in fact delays the proceedings in Congress. Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president.
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
A president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
well, I thought
pattern.
you said it, that was my question.
Yes,
and
I
you said it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2.
He could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily to violate
it.
Okay.
Nobody knows what corrupt intent means. We've been around that tree
we will probably
already.
Find out.
And maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from going
Well, let me get to the next layer then, which is that the president does have access to the attorney general to provide legal advice and regularly gets legal advice from the Attorney General on the lawful scope of the President's activities. And we could go down two tracks here. One is that the Attorney General advises him that as an incident of his Article 2 authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the First Amendment analog to the President's official powers, which the court is exploring in other cases. Alternatively, the Attorney General could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that. And I would advise you not to violate criminal law.
And then he could be prosecuted.
No.
If he gets a negative opinion from the Attorney General, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Dreeben, can we go back to
So, ladies and gentlemen, to my super chat, thank you. Secret Spaceship, thank you so much. As you can see, and hit subscribe to this channel, to my super chat. Again, thank you so very much to the members. Thank you of this channel. Number one, we start off, and you can look back as you're watching and just go back. The analysis is the following. We started off with the justices asking, well, wait a second, what's an official and unofficial act? The indictment claims that nothing Trump did was protected. How could that be? How could it be that the indictment was so poorly written that everything Trump did was criminal in nature? From his intent, even though he intentionally he believed with all his heart, and he still does, that he was railroaded like Bernie Sanders in the DNC primary in 2016. There was not 1 second in the past 4 years that Trump believed that Democrats treated him fairly. Also, a speech was protected by presidential immunity. He did not tell anyone to commit a crime. So why is he being, why do they want to imprison this man? He didn't break into a bank. He didn't commit a crime that is, on its face a crime. He performed a speech. The speech had nothing to do with people impeding or stopping a congressional proceeding. That didn't stop a congressional proceeding. His speech had nothing to do with the criminal behavior. But Democrats accused him, and then by virtue of accusing him, they say, well, because he was accused and indicted, therefore, we know there's criminal and corrupt intent, and his activities were beyond the scope of official acts, and only official acts are protected. And then the justices said, well, what do you mean? How do you know this? Oh, well, because he was indicted. Well, what if he was indicted for political purposes, which of course he was? And they ask him that. They're like, well, and then the special counsel lawyer says, well, there's a grand jury, and people swear an oath to protect the Constitution, and they would never do anything like that. Well, then why wasn't Biden indicted? By his special counsel. Oh, because he's a Democrat. He committed crimes, but the special counsel stated, oh, well, he's an elderly man with cognitive issues, so therefore in no reasonable court. But they found an unreasonable court to try to imprison Trump for 100 years. Then they go on to say, well, aren't you changing and altering the presidency forever? Oh, no, not at all. I mean, after all, he has an attorney general. All he has to do is ask the attorney general. Well, what if the attorney general gives the wrong interpretation of the law? Okay? And it's like at each level, each step here, the special counsel is being eviscerated. Their argument is simply, we indicted Trump. We were completely apolitical and nonpartisan. And because we indicted him, nothing he did as president was protected under the Constitution. When in reality, you can't just indict a president. You can't just indict a president and hit subscribe if you're new to this channel. You can't just indict a former president and say that a speech that he performed was a criminal act, because his speech will likely be protected as an official act as president. He was still president. He was able to perform a speech. Too bad, Democrats. And his speech told the world that he was railroaded by his opposition. Too bad. He's allowed to say that. And so it's going to go back to the lower court, which is exactly what Alito talks about. And the lower courts are going to then decide, well, what's an official act? What's an unofficial act? And then you'll go from there. This is really a huge, huge, huge victory for Trump. Check this out. Clarence Thomas does a brilliant job. Justice Thomas does an absolutely brilliant job here.
In assessing the official acts of a president, do you differentiate between the president acting as president and the president acting as candidate?
Yes, we do, and we don't dispute, essentially, the blazing game discussion of that.
Okay.
But of course, that has to be done by objective determinations, not by looking at what was the purpose of what you did this. And that's the most important point there.
Did you, in this litigation, challenge the appointment of special counsel?
Not directly. We have done so in the Southern District of Florida case, and we totally agree with the analysis provided by Attorney General Meese and Attorney General Mukasey. And it points to a very important issue here, because one of their arguments is, of course, that we should have this presumption of regularity. That runs into the reality that we have here an extraordinary prosecutorial power being exercised by someone who was never nominated by the president or confirmed by the Senate at any time. So we agree with that position. We hadn't raised it yet in this case when this case went up on appeal.
Justice Alito?
When you say that the official act should be expunged from the indictment, that in itself would not achieve very much unless evidence of those official acts were precluded at trial. So is that what you're saying, that the prosecution should not be permitted at trial to prove the official acts as part of the conspiracies that are alleged?
Absolutely. And we think that's just the clear implications of Brewster and Johnson and their discussion in a very analogous context.
Thank you.
Justice Sotomayor?
I'm a little bit confused by that. If you have a scheme to defraud or a scheme to accept bribery, there's evidence from which you can infer that scheme, and one of it is that the appointment actually happened. It's an official act. You wouldn't expunge that as evidence. You would instruct the jury that there's no liability for the actual appointment, that the liability is for accepting the bribe. Similarly here, I don't think the indictment is charging that the obstruction occurred solely because of conversations with the Justice Department. They're saying you look at all of the private acts and you look in the context of some of the public acts, and you can infer the intent, the private intent from them. So I'm not sure that I understand why your problems couldn't be taken care of at trial with an instruction, if the court were to find, I'm not even sure how they could, but if it were to find that some public acts could not be the basis of criminal liability.
I think the best thing I can say to that is, and I think this ties into the Chief Justice's question about a one-legged stool. Brewster and Johnson and subsequent cases like Heltowski versus Meaner essentially say that this is a one-legged stool problem. It will be difficult for some of these prosecutions to proceed, and that is the implications of official immunity, which is dictated in the Constitution here by the Executive Vesting Clause.
So that was actually Trump's lawyer speaking to the justices, and I believe you had Justice Sotomayor after some of the conservative justices. The issue is that he is protected for official acts. You have to find out what was official and what was unofficial. Furthermore, in response to Justice Sotomayor, they're accusing Trump of knowingly trying to impede and prevent the transfer of political power based on his quest to remain president. This is not the case. This has never been the case. Trump believed that the results were derived in a very illegal or foul or unjust manner. Okay? Similar to the DNC primary, where the DNC chairwoman in 2016 was forced to resign, then promptly joined the Clinton campaign. The 371 statute, and you could use that. I wrote a Federalist article about how certain government officials broke that statute. The 371 statute talks about defrauding the American people and the government. They're trying to say that Trump deliberately deceived the country. Well, a good part of the country agrees with the claims Trump made, despite the best efforts of every fact-checking journalist. Why? Because there was not one investigation where a person was forced to testify under oath, unlike the Mueller probe, which was based on a completely conspiratorial theory that Trump was an operative, and the Steele dossier, which was purchased by the DNC and the Clinton campaign, and the FEC fined the DNC and Clinton campaign. They did not find Trump, yet the hush money case in New York is trying to imprison him, even though he was never fined. So you have to differentiate. This is why they are in. This is why the Democrats are going to fail yet again. There are official and unofficial acts as president. You cannot simply indict and prosecute and imprison a president because you said, well, the mere fact that we accused him of these things means that he has no constitutional protections. That's absurd. They're doing this for political purposes right before November, specifically to interfere. There is not one shred of objectivity or care about the rule of law. It's just because they know Trump's up in the polls. They could have done this a year to 2 months after January in 21. In March of 21, they could have done this. The Federal Bureau of Investigation stated that there was no evidence of a concerted effort to rebel against the country. It was completely spontaneous, had nothing to do with what Trump said in a speech. But again, they're trying to criminalize things that aren't criminal. A speech by itself is not a criminal act. Trump speaking to administration officials or officials in other states is not a criminal act. They're saying it's a grandiose attempt at deceiving the country. The indictment was written by it was like, if you read the indictment, it's like written by an MSNBC or CNN producer. Let's go ahead and listen to Justice Thomas again.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article 2 branch, can assert as applied Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which is...
Well, that's not true. Number one, where was the crime? These are very broad statutes, okay? The 371 statute, defrauding the United States, is a very broad statute. So where was the actual crime? Because Trump performed a speech where he truly believed what he was saying. And he performed a speech he had every right to perform. So where was the crime there? There was no crime. He didn't break into... It's not like Trump is defending himself because he broke into the Watergate building or robbed a bank. He performed a speech. Okay, they're getting Trump on a speech. They're getting Trump on an NDA. Meanwhile, Hunter and Joe have obvious graft and bribery schemes, and they're like, there's no evidence there. And so, but where's the crime with Trump? Because he is protected as a president to perform a speech. He did not, like I said, break into a bank. Okay? They're using very broad and vague and ambiguous and, all-encompassing legal statutes to say, well, all of these legal things he did, it was a plot to continue to remain in power. That's not what Trump was doing. He went through the courts. He did literally, when he says he did nothing wrong, he literally did nothing wrong. You could use these statutes, for example, against Joe Biden, who lied about knowing about Hunter's business deals. He knew about Hunter's, but he lied through his teeth. And then 50 Intel officials lied also. But they would never use those statutes against Biden because he's a Democrat.
Has never happened in our history, and we submit that is not necessary in order to assure that the president can perform all of the important tasks.
Also, he was acquitted. So the special counsel argument is, well, even though he wasn't convicted, we still have enough evidence to convict him in a court of law. It's like, well, but he was already tried in the Senate. If what he did was such an egregious, unlawful, illegal activity where he tried to, foment a rebellion and well, then why was he acquitted? Because these are Republicans. Well, they swear an oath to protect the Constitution also. Oh, so we should only trust the grand jury and prosecutors from the special counsel. Oh, because when they promised to uphold the Constitution, they really promised, unlike the Republicans and I think a couple Democrats who acquitted Trump. So you see that they're just so desperate to imprison this man. And yes, he cares very much about the country. Name a politician who would face all of this and still go and win another term. Then they say, well, we're mainstream. Like, no, you have a 2-term, because he's going to win in November. And so you have a 2-term president, and they say, oh, the Make America Great Again Republicans are extreme. It's like, no. The people who vote for Trump will be mainstream after he wins a 2nd term. The people who were the resistance, remember his 1st term, and trying to imprison him, they will be the extreme.
That the Constitution reposes in him.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right.
Yogi, thank you so very much. By the way, this is very, very important. Thank you again to my super chat. Thank you, Yogi Fish. Thank you. This is very important. Check this out. Clarence Thomas, Justice Thomas, talking about a very, in terms of international law, illegal activity by a president, by a government. And the response is, well, presidents can destroy countries or attempt to overthrow countries. That's not a problem. But a speech is a problem.
No prosecutions. Why? If what you're saying is right, it would seem that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain.
What you're saying is right. When I was operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right, it would seem that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal.
To my super chat, thank you again. There are layers of safeguards. So whenever, and you heard this with the January conviction, the Supreme Court arguments regarding the disparity in sentencing for January defendants. Whenever the Supreme Court justices catch the government lawyers in a double standard or defending a double standard, they say, well, the response is, there are many layers. It's true that that presidents have done worse than Trump, but see, that's allowed. In this case, we can prove it because we've indicted Trump and he's not above the rule of law, even though we haven't even decided what is an official or unofficial act protected by the Constitution as a president. But Justice Thomas brought up a very, what can be easily considered an illegal foreign policy activity. Okay? And you then get, oh, well, that's different. So they're not really, they never answer the question like, yeah, Trump committed a crime just like someone else did. They always say it's such a unique moment in history. We just had to indict and try to imprison Trump. I mean, there's just never been an example where a president did this. Yeah, there's been examples where presidents did worse. Justice Thomas just told you one. And President Obama intervening in Libya, one of the worst catastrophes in U.S. foreign policy history, turned that country into a failed state. And that was President Obama's biggest mistake. And still, he can't be imprisoned for that. You're not going to imprison any president for foreign policy. Bush, nobody. So they always see they're just trying desperately to imprison Trump. That's it. Secret spaceship. Yogi Fish, thank you. Experiencing U.S. history with a great independent. Thank you, journalist who loves the Constitution. Your honesty and fairness are noted, and your opinion and humor are needed. Thanks. Secret spaceship, thank you. Thank you so very much for the kind words. Greatly, greatly, greatly appreciated. Yogi Fish, thank you as well. To my super chat, thank you. So, Secret Spaceship, everybody here, they're trying to, Yogi Fish, they're trying to imprison Trump. And they don't even have a clear understanding of whether or not some of his activity was protected. The special counsel wrote a very broad, ambiguous indictment. What they're going to do is one or two or three or four of the things that Trump was accused of, he's actually going to be protected by the Constitution is going to protect him from prosecution. Because if a precedent is set where a speech could land you in prison, every single speech in the future will be looked at by 1,000 lawyers before a president performs the speech. It will not only weaken the executive branch, but it will make the executive branch function like a public relations firm or like some kind of deposition. Presidents won't speak to the American people. They'll be reciting words as if they were in a deposition. And so that's the issue. And it's like the norms and traditions have been torn apart, and the response is, well, Trump is so unique. It's like, no. Trump did nothing wrong. What's unique is your animus towards this man. Secret Spaceship, thank you again. To my super chat, thank you.
Liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the attorney general, and it would be
Why would that be a layer of protection? Anybody who sided with Trump would be a henchman of Trump. A henchman. Trump. One of his gangsters. Trump. His attorney general gave him the wrong advice deliberately and willingly. Both of them should be prisoners. An Alcatraz. But now it's a layer of protection, don't you know?
a due process problem to prosecute a president who received advice from the Attorney General that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law.
So, ladies and gentlemen, they're already writing what we learned from Trump's surprisingly good day at the Supreme Court. What did I tell you, ladies? This is Politico. I showed you an Axios article in the segment earlier today. What did I tell you, ladies and gentlemen? I told you, and people say, "Oh, well, sometimes your titles," and it's like, no. Everything I say, it's either going to happen or already happened or ahead of the curve. And hit subscribe to this channel. This is going to be a landmark decision, ladies and gentlemen. This is going to be a huge, they can have their little stupid victory. They can try to call Trump a convicted felon, Trump, with the hush money. He hushed Stormy with money. Which, by the way, that's extortion because anyway, if you accept money in an NDA, 130 grand, and the FEC does not view it to be a crime, but they find Clinton and the DNC, and then you say, "Oh, well, I'll tell the world if you don't give more money." I think that initially took place anyway. This is a huge landmark victory. The DC case, this special counsel case, is the one that could really, really, really hurt Trump. This is imploding like I said it would. Okay. The classified data case, that's already, Trump is a president with the power to declassify. That's not going to happen before November. The Georgia case has completely dissolved and imploded, and it's in shambles. That ain't happening before November. The DC case, he's going to get immunity. That's definitely not taking place before November. He'll dissolve the special counsel as president. The other cases as president will turn into nothing. He'll either dissolve those cases or, like this special counsel case in D.C. and the classified data case that the special counsel brings. The special counsel is an executive, part of the executive branch. He'll do away with that, as he should, immediately. His first thing that he does in office, purely political partisanship. The Georgia case, that will go under, especially if he gets partial immunity, when he gets partial immunity, because he'll be immune, and that'll have to be rewritten, and that's probably just going to become nothing. And the hush money case will be the only thing Democrats have, and that will be overturned if they convict him in the Court of Appeals. He'll win in November, and then it'll be very interesting. Hit subscribe to this channel. God bless you all. Be here in November and beyond. Every single day, ladies and gentlemen, is a countdown to November. This country needs Donald Trump. We're crumbling. In terms of foreign policy, domestic policy, we are not doing well as a country. And it's because of a very inept president we have currently, and a political party that is really, really corrupt, propping him up. Not intimidated. Thank you so much. Thank you. Gloria, everyone here. Grandma, hello. Everybody here, thank you so very, very much. Micro Blue, hello. Everyone here, thank you so much. To the members, thank you. God bless you all. I'll see you tomorrow, everybody.